Well, thank you, Alden. That's very kind. But if you want to understand the real meaning of stress, you should picture yourself as the last speaker of the day and standing between 100 people and the bar downstairs leaves me in an unenviable position. But I will, with the half an hour that I have, try to give you a few insights into the journey that I went on for about 16 years from start to finish. As you know, the wheels of justice move slowly. I want to start by emphasizing that although I am a bencher of the Law Society of Ontario, formerly known as the Law Society of Upper Canada, I don't share the view of a number of people who think the Law Society changed its name because of the embarrassment that it suffered in my case, but there is that view that's out there that you'll hear expressed from time to time. But I'm here on my own behalf, and you'll get to talk to Malcolm later, who's here as the official spokesperson of the Law Society. So I think you should assume most of the benchers will take much of what I have to say with disagreement or disputation, or perhaps even worse. Secondly, I do commend Sam's good paper about the issues of stress in the profession. I do personally believe the Law Society's done a lot of work trying to help lawyers and others with dealing with stress issues and mental health issues, and although there's more to be done, I think in that particular area, the Law Society is doing a reasonably good job. Of course, the only typo that I could find in the paper is that our winery, which is 16 Mile Cellar, is referred to as 6 Mile Cellar. And so if you have to make the worst possible mistake you can make, it's when you're trying to sell wine to 100 people and you give them the wrong name for the winery. And then lastly, in order to understand what I'm going to try and talk to you about, I want to give you a 90-second nutshell overview of what the Felderhoff OSC Law Society Groia case looked like, because it really provides, I think, the context for what I'm going to talk about in terms of the personal issues that one deals with, both in defending a high-profile quasi-criminal prosecution and also in defending yourself if you ever find yourself charged by a regulator with professional misconduct. So in 1997, Bre-X Minerals was the darling of the Canadian capital markets. It was a penny stock in Alberta that went from 20 cents to about $225 a share. It had a market capitalization of $6 billion. And my client, or who became my client, John Bernard Felderhoff, was at the Roy York Hotel about to get the most prestigious award that you can get in the mining industry, the Prospector and Developers Association Prospector of the Year. Think of it as the equivalent of a Treasurer's Medal or a LLD from the Law Society. And his phone rang, and on the other end was a mining executive at Freeport-McMoran named Jim Bob Moffett, a Texan, larger-than-life personality. And he proceeded to have a very coarse exchange with Mr. Felderhoff to explain to Mr. Felderhoff that this deposit in Busang in Indonesia, which was thought to have 80 million ounces of gold, they couldn't find any at all. And so Mr. Felderhoff didn't take kindly to that. He went down the hall to the door of Michael de Guzman, who was the chief of exploration and who ran the actual camp. Mr. de Guzman was in Toronto in order to be in attendance when Mr. Felderhoff got his award, and he was in the company of two strippers from For Your Eyes Only on King Street, and was spending the weekend engaged in all of the sights of Toronto that one can possibly encounter during the course of that weekend. So they had an exchange, and Mr. Felderhoff got Mr. de Guzman to go back to Jakarta. He never got back to the property. The suggestion is he was pushed out of a helicopter and murdered. I actually believe he's alive and living somewhere in the Philippines. I will hasten to add, I don't believe Elvis is alive and living in Mexico. So if you want my reasons for why I believe that, I'm happy to tell you about them at the open bar over the course of dinner. But eventually it turned out that Bre-X was a $6 billion salting scam, the most complicated mining scandal in the history of North America, one of the largest frauds in the history of the capital markets. It was responsible for significant changes in the mining reporting and auditing process that the Commission follows. For those of you who do any mining work, 43101 reports are now an outcome of the Bre-X case. And so Mr. Felderhoff had very serious problems when I met him in the Cayman Islands in March of '97. And he wanted me to represent him dealing with not only the Ontario Securities Commission, but the Securities and Exchange Commission, the FBI, the Department of Justice, the RCMP, the OSC, and every other regulatory agency you could think of. I asked Mr. Felderhoff to take a lie detector test, which he did in Montreal and passed with flying colors. And so what was left, as far as I was concerned, was the suggestion that Mr. Felderhoff knew or reasonably ought to have known that salting was going on. So 2 years later, in March of 1999, we were told by the Securities Commission that the RCMP was not going to lay criminal charges, but they were going to lay 8 counts of violating the Securities Act. And Mr. Felderhoff was looking at 40 years in jail had he been convicted of those charges. Now, that trial began in the fall of 2000 before Justice Peter Rinn of the Ontario Court of Justice, and it was a difficult case. It was clear to me the prosecutors were under an enormous amount of pressure in order to secure a conviction. And of course, there was a high publicity level. For those of you who know the Cura decision, Westray mining decision, it was the classic, what Leroux called the lynch mob searching for a tree mentality that lay behind the prosecution. So it was a tough case, and I think it's fair to say if you read the decisions I gave as good or better than I got. But as Archie Campbell said, there was no monopoly on incivility in that case. So we did 60 days of trial and battled back and forth, and the Securities Commission, during a break at Christmas, brought an application to remove Peter Rinn as the trial judge on the basis that he was biased in my favor, and that he was making rulings against the Securities Commission which demonstrated that he had lost control of the trial and had otherwise not conducted himself in a manner that was befitting that of a judge of the Ontario Court of Justice. That was argued initially before Justice Archie Campbell. During that argument, Brian Greenspan was retained to represent Mr. Felderhoff because at that point 25% of the allegations were based on alleged misconduct that I had engaged in. And during the course of that hearing, as was reported in the Globe and Mail, the prosecutors for the Securities Commission called me a bald-faced liar and also said that I was like a terrorist who threw a bomb into a bus shelter and ran away. Now, this is November of 2001, so you can imagine what the atmosphere was like when those submissions were being made. Justice Campbell made the observation there was no monopoly on incivility, but my conduct was harshly criticized, and he described some of the things I did as akin to guerrilla theater and petulant invective and other kinds of words. But what's important from my perspective was we made a decision not to actively defend my conduct. Brian Greenspan told me that in his view it would be bad if we defended the conduct because there was an increased chance that Justice Rinn would be removed and Mr. Felderhoff would have to start all over again. So I spent 2 terrible days being harshly criticized with no defense of any real import being mounted. And Justice Campbell decided against the commission, went on appeal to the Court of Appeal, Justice Rosenberg writing for 3 judges. They also harshly criticized my conduct, but they also dismissed the application on the basis that, in their view, Justice Rinn had been patient and even-handed to a fault. So we went back in front of Justice Rinn. As luck would have it, the prosecutors were fired by the Securities Commission, and they were replaced by the then Treasurer, Frank Morocco, and his colleague, Emily Cole. And we did another 100 days of trial over the next few years. And at the end of that, in the summer of 2007, Mr. Felderhoff was acquitted of all the charges against him on the merits. In the middle of the trial, Mr. Felderhoff ran out of money. And so we did $2 million worth of legal work for which we never expected to be paid because we weren't prepared to give up on his defense in the middle of the case. So I had been called, and then a letter was written to me by the Law Society in the summer of 2002 telling me that they'd read about me in the newspaper and that they had opened a file into my conduct and did I want to put the possibility of an investigation on hold while the trial was continuing. I agreed to do that. So within a few weeks after the decision came out, I wrote to the Law Society and I said, the case is now over. I'd like to deal with any issues you have. And they wrote me back and they said, well, we would like your comments on the findings of misconduct that have been made against you by the courts in the Felderhoff matter. And there was a series of letters that went back and forth where we discussed that, and I tried to explain to them, in my view, no findings had been made. I was not a party, I was counsel. But I was unsuccessful in persuading them that, in fact, there was a difference between what Malik talked about as a party or a near party and what they were describing as my conduct during the course of the trial. But I was unsuccessful, and so in the summer of 2009, I was charged with 6 counts of professional misconduct for failing to act in good faith and failing to act in accordance with what we generally call the rules of civility. And we then began, I retained Earl Cherniak to defend me, and we began a long process from 2009 to 2018 at defending those charges. So we went to a hearing panel presided over by the then Treasurer Conway. It was decided at the hearing panel that I was guilty of professional misconduct, that my attempts to defend myself were an abusive process, that I was wasting the time of the Law Society by calling evidence. The Law Society prosecutors called no evidence. I called 9 witnesses, testified for 9 days. But I was convicted on all the counts, and because I failed to show appropriate remorse, it was said I should serve a 2-month suspension and spend about $250,000 in costs. We appealed that to an appeal panel, and the appeal panel overturned that decision on the basis that the legal concept which the hearing panel invented, which they called I was a party in substance, a new term that had never been heard before, was simply an inappropriate way of looking at the conduct of a lawyer acting for a client as counsel in a courtroom. And so the hearing panel started over de novo, and 5-0, they convicted me all over again of misconduct. And they reduced my sentence, however, to a 1-month suspension and $200,000 in costs. And they overturned also the incredible statement by the Law Society hearing panel that criminal defense lawyers have an overriding duty to ensure that trials are conducted efficiently and in an atmosphere of calm, and that takes priority over your duties of loyalty and fidelity to your clients. That also got overturned by the appeal panel. We went to the Div Court. I lost 3-0. Justice Nordheimer said the appeal panel applied the wrong test, but I was such a bad person, I would have been convicted on anybody's view of the rules of civility. And at that point, now that I was down something in the neighborhood of 19-0, if you add up all the judges and regulators, I decided to run for bencher. And that was one of the hardest things I ever had to do in my entire life. If I had not been elected, I think I would have been crushed. But as it turned out, I was elected. I got about 3,500 votes. And if any of you voted for me, I want to personally thank you for doing that. And so I became a bencher of the Law Society, and I was worried the Law Society may not treat me perhaps as well as I would hope for. I'll digress and tell you a small anecdote. In 2004, in the middle of the Bre-X mess, I was a special lecturer at the Law Society special lectures on corporate law. And if you're a special lecturer, you get invited to a dinner. And when I got to the Great Hall to sit down for dinner, all of the other people who were talking on the panel were at the head table. And my table, for some remarkable coincidence, found myself outside the dining room in the hallway where I was seated with a number of staff members and some articling students. And so I just decided to take the opportunity to be loud and rowdy and noisy. And we had a very good time, and all the people in the dining room kept looking out to see why these people in the hall were having so much more fun than they were actually in the dining room itself. So then we went to the Court of Appeal. I got a dissent from Justice Brown, so the score was 21-1. I sought leave to the Supreme Court of Canada, and in June of this year, I'm sure you all saw that a miracle occurred, and the Supreme Court, on a 6-3 basis, overturned my conviction, said the appeal panel's decision was unreasonable. I'm embarrassed to tell you, I called that decision 100% wrong. I thought I was going to lose. I thought my only chance would be on Dunsmuir correctness. And I thought if they ever went to reasonableness, there was just no way the Supreme Court was going to say the Law Society panel was so out to lunch they couldn't get a decision that fell within the boundaries of a reasonable result. And so since then, I've been dealing with thinking about that very long journey, but Eldon was the first person who kindly asked me to come and talk about it from a personal standpoint. I actually have gone across the country teaching students about the rules of civility and what I call shades of mediocrity and the perils of an undue emphasis on civility. But what I'm going to talk about in the 12 or 13 minutes I have left are what I'm going to call the 10 most amazing things that you discover when you're charged with professional misconduct. And for those of you who may have to leave, I'm going to do them, of course, as Letterman used to do, from 10 to 1. But for those of you who read the last page of Murder Mysteries, the number one thing I'm going to talk about at the very end is that we are not superheroes, that for those inspirational lawyers and other speakers who come and talk to you about all the great things you can do as a lawyer and how you can be a superman or a superwoman, I have to tell you, to quote the immortal Vinnie Gambini, everything that guy said is bullshit, in my opinion. And what I am going to say is that if you are a superhero or think that you're a superhero, then stress is the kryptonite in your life that will bring you back down to earth. So that's number one. Let me go back to number 10. I discovered, and I'm going to do 10 and 9 together, I discovered the importance of what Angela Duckworth calls in her remarkable study of successful people, grit, the importance of both passion and perseverance. And she describes passion as a focused energy towards a particular goal that you've identified. And she describes perseverance as, of course, the Winston Churchill, never, ever, ever give up. And I can tell you there were lots of times when I was down 21 to 1 and I was spending millions of dollars in legal fees, and I was dealing with the stress of trying to run a small law firm and run a small winery and do all these other things. There were lots of times I thought seriously about giving up. And it can be a very lonely battle when you're dealing with stress. And one of the things the paper tries to emphasize is the importance of using resources that are available, but also using resources that you have in your personal life. And I want to come back to that. But what you'll learn if you read Grit is that the secret of being successful, the secret of really doing the best you can as a professional or as a person, is to be really dedicated towards pursuing a goal as best you can and sticking at it no matter how much adversity you think you're going through. And I can promise you, there were lots of days, especially when I would sit in Earl Cherniak's office and he would beat me around the head about some other idea I had, where you really needed to have a huge amount of emotional energy just to stay the long course that I had ahead of me. Number 8, settling cases is highly overrated. And it's, in my experience, you really ought to think very carefully about the stress that comes from being put into a position where, as I was I going to fight with the Law Society or was I going to settle? When I was approached by the Law Society, there were discussions that went on about the possibility of a resolution called a regulatory hearing. And I went and spoke to 20 or 25 lawyers in downtown Toronto, and every single one of them said, Joe, you should settle. You can't win with the Law Society. You can't afford to have this fight. It's going to be long and painful. Everybody's going to suffer. Just take the deal and run. And, you know, we've all had those discussions with our clients, and we've all had the person accused of the criminal offense who comes to you and says, I didn't do it, but the Crown is prepared to make an offer that you can't refuse, and you deal with the stress of trying to advise somebody in that circumstance. And all I can say to you is that what you need to do, I think, ultimately, is to understand that settling is a really bad idea for many people, including in my life. If I had taken the deal, I wouldn't be sitting here today, of course. I probably wouldn't have run for bencher. And more importantly, I would have had to own that deal for my entire life. I would have had to admit to having done something wrong that I really in my heart didn't believe in. And so saying no turned out to be a huge stress reliever because I was able to do something that I felt was really authentic and something that made sense to me on so many different emotional levels. So when you're in a circumstance where you're provided with that opportunity to settle and get out, think very carefully about it, because settling, I think, is highly overrated. Now, this is a controversial one that I suspect the Law Society people here today will bristle a little bit. But in my view, every lawyer needs to be charged, sued, threatened, complained about. You have to have somebody mad at you on a regular basis. Now, not your family, of course. That's a different discussion. But if you're not doing something that really pisses off your opponent once in a while, I don't think you're doing your job well enough. The essential quality of resolute advocacy, in my experience, means you're not going to be a nice person. Our job is not to be popular with our opponents. Our job is to defend our clients. When I was a student, I was blessed with a chance to work for Ian Binney before he went on to Ottawa and then the Supreme Court. And one of the first things Ian taught me that I've always remembered and tried to teach every student I've ever had an encounter with is, when you're representing a client, she is the most important person in your whole life. What Queen Caroline's case said is really true. And so you have to keep in mind that when you're doing that, you're doing things that your opponent is not going to like. The easiest way to settle a case is get whatever deal you can and beat your own client up into taking it. Well, that's not why we're lawyers. That's not what we do as professionals or as advocates. What we do is make the other side beat up their client to take our deal. And so if you're not in an encounter where somebody isn't mad at you on a regular basis, I really want you to think about whether you're doing your job at the level of excellence that I'm hoping everyone in this room strives to accomplish. Number 6, Eldon won't like this one, but where were the law associations when I was going through this long ordeal? And by the time we got to Supreme Court, everybody wanted to be involved in my case. We had more interveners than Carter had liver pills, but all the way along, the hearing panel, the appeal panel, the div court, it was only when we got in front of the Court of Appeal that we had several interveners. And what I think law associations need to do, not only in the representation of your members, but also in your job as stewards of the legal profession, is you have to look at what's going on at the Law Society and the regulatory process. And if you see a case where you think it doesn't make any sense, you have to stand up and say, that doesn't make any sense. We're going to support that person. Now, I'm not sitting here saying, the next lawyer gets charged with stealing money from his trust account, you want to rush to their defense, because obviously there are some lawyers who are dishonest and who deserve to be disbarred, and worse, in my view, they deserve to be prosecuted. But when you have all kinds of other cases that involve errors of judgment, or a lawyer who's got a medical issue, or a health issue, or an addiction issue, those are all areas where I think the profession as a whole has to have a voice, and it has to use that voice loudly and strongly, because I felt very lonely all the way up to the Supreme Court, and then in the Supreme Court it broke down sort of 6 and 6. There were a number of people intervening on my behalf, there were a number of intervening on behalf of the prosecutors. But I really do think that you want to look very carefully at enforcement cases that come out of the Law Society, and in cases where you think it's appropriate, you need to put your oar in the water. Number 5, dealing with Law Society prosecution, you find out who your friends are. I would get stopped on the street by total strangers, and they would say, you don't know me, but we know who you are, and we really support what you're doing, trying to stick up for the profession. And again, in terms of the stress that I had to deal with, I had a very good group of friends and a very closely knit family, and I was able to call on them and their emotional energy at times when I didn't have a lot of my own to be able to deal with all the forces that were weighing heavily on me. And so, again, I think you make a mistake trying to do this on your own. Doesn't have to be professional help. In fact, for those of you like me who have a commitment to a faith, I think your faith also has power that you can rely on that gets you through some of those difficult days. And so you really want to look at the importance of a support group getting you through those difficult times. Number 4, the importance of distraction. I started a winery because I needed to do something to get me out of the funk that I was going to be in for fighting with the Law Society. It turned out to be its own form of insanity, and for those of you who want to talk about running a winery, I'm happy to do that, but I don't recommend that unless you have an unlimited pocketbook and a willingness to go into restaurants and try and sell wine to very young people who are picking up their emails rather than listening to you. But having a distraction, it's a form of mindfulness. If you understand the basic elements of mindfulness or meditation, it's taking your physical and your emotional and your mental powers and directing them in a way that takes you out of the problems you're dealing with and focusing them on somebody else. And number 3, the importance of fighting back. I talked to you about being elected. That was a huge step in my life because what it gave me was the validation that this fight was not just me against the Law Society. It was a fight that 3,500 other lawyers shared at least some of my views. And so running and winning and becoming a bencher turned out to be a hugely important step because it said to me, you know, I'm not as bad as, at that point we were up to 21-1. 21 judges and regulators think I am. And if I am as bad, then I've got 3,500 other people who must be just as crazy as I am, thinking there's something wrong with this approach to the civility movement. Personal stress, my paper talks a little bit about how you can, I think, and my experience teaches me this, you can really rank the stress levels and the types of stress that you're dealing with. Clearly, it's very important to try and understand what is the element that is causing you stress. And in my life, in 2012, one of my family members was diagnosed with a very severe form of breast cancer. Another family member in 2015 almost died when he fell off a 3-story roof as an industrial accident, and I spent weeks at the St. Mike's Hospital with my son in a medically induced coma. And then my daughter got very sick with a rare blood disease. So I can promise you, there was nothing the Law Society could do or any professional obligation could do that comes within a country mile of the issues that you tackle when somebody in your family is very seriously ill. Now, obviously, that's not something you choose. I certainly didn't choose it, but I can tell you it just knocked my Law Society stress right out of the park, and it couldn't have mattered to me in the slightest what was going to happen to me in those weeks and months when I was dealing with those other problems. And then finally, back to number 1, we are not superheroes. You're not someone who's invincible. Lawyers, by their very nature, show equal qualities of perfectionism, paranoia, and pessimism, which make us ideal candidates for stress and stress factors. You know, there's lots of literature talking about the number of lawyers who over-abuse both prescription drugs, non-prescription drugs, and alcohol. In every other area of professional life, the more successful you become, the less stress you have, except in the practice of law. The more successful you are, the more stress you end up adding to your own life existence. So in conclusion, I want to come back to Mr. Felderhoff, because at the end of the day, this was all about representing him and trying as I could to live up to a promise I made to him that I would see him get home safe, which ultimately he did. But he paid an enormous price. His marriage broke up, his family broke up, he ended up moving to the Philippines. He's destitute, lives with his adopted family outside of Manila. But his family, when my decision came out this June, his family, and he's got a very large extended family in Nova Scotia, wrote me the most wonderful letter and sent me an oil painting that one of his sisters had done of John that I have hanging in my office. And so every day when I come to work and I think about this long 16-year ordeal, and I look at John, I say, you know what? It was all worth it, because there's a guy who counted on me to see him get home safe and for better or for worse, I was able to do that. So thanks for your attention. It's time to go drinking, but if you do have a question, I'm happy to talk to you one-on-one, or Eldon, by the powers vested in you, if you want to keep them from the bar, you can do that. So.
I'm going to keep them for 2 seconds, and then I see our illustrious soon-to-be leader coming forward. It's his task. But I want to share this with you. I did some investigation into Joe before he came, and one of the things I learned about him is that he's inspired by Clarence Darrow. And I was looking at quotes of Clarence Darrow, and I thought, yeah, I think this probably sums it up, but I'm going to wait and see what Joe has to say to us first. This is a quote from Clarence Darrow that I think may summarize a little bit of what Joe's told us. It says, "I've lived my life and I've fought my battles, not against the weak and the poor, anybody can do that, but against power, against injustice, against oppression. And I've asked no odds from them, and I never shall." I just thought that was a great quote, and knowing some of the story, thanks for sharing the rest with us. And
well, the other Clarence Darrow anecdote I'll share with you is that he conducted a trial in California where the prosecutor was bribing jurors, and so he went out and bribed his own jurors. And there's actually a wonderful article written called "Fighting Fire with Fire." But as a result of that, he was charged with criminal offenses, and he was defended by Earl Rogers, who was too drunk to make the closing address. So Darrow did it himself, and he got a hung jury in the first case and then an acquittal. But the State Bar of California went after him and disbarred him and said, "You're no longer welcome to practice in the state of California." And as he was getting on the train to go back home to Chicago, Illinois, he said, "Never have I been so happy to be kicked out of any place as I am the state of California." So I often think about Clarence and fighting fire with fire.
Well, Joe, the sort of the theme, if we have one, of this plenary is mental health. So when we were sitting around the executive table, we thought, what lawyer do we know who's really been through a heck of a lot of stress? And I'm sorry to say, your image immediately popped into our minds. So we thank you very much. You've opened up. You opened up about your family. We appreciate it. You've been very gracious. We have a small thank you, a gift. We've made a donation in your name to Lutherwood, which is a local Waterloo Mental Health Association.
Thanks very much. Okay, thank you.